Hello and welcome. I am Lian Buan and this is Rappler Talk. On December 7, months long of rumbling in the legal and justice circles bore fruit. An impeachment complaint was filed at the House of Representatives against the fiercest dissenter in the Supreme Court, Associate Justice Marvic Leonen. The complaint was filed by a certain Edwin Cordevilla of the group Filipino League of Advocates for Good Government. It was endorsed by Ilocos Norte 2nd District Representative Angelo Marcos Barba, the cousin of former Senator Bongbong Marcos. Cordevilla was represented by notorious lawyer Larry Gadon, who was also behind the impeachment complaint against former Chief Justice Maria Lourdes Sereno. And to talk about that and more legal issues about the impeachment complaint, we have the former national president of the Integrated Bar of the Philippines, Attorney Abdiel Dan Elijah Fajardo. Attorney, good day po.
Hi, Lian.
Yes. Attorney, I will go to straight to the question is, SALN na naman yung binabanggit laban kay at Justice Leonen. What did you think of this when you heard that? Kahit bago pa yung impeachment complaint, when the first SALN rumblings began nung humingi si Soljen Calida ng copies of SALNs ni Justice Leonen sa Anbank, what did you think of that?
Well, I thought that it was a predictable move because precisely it is a tested formula that was tried against no less than the Chief Justice around 2 years ago. So I saw that it was a patented move actually by the lawyers. No? Well, initial thoughts is that it was successful before, so there's no reason really for them to depart from that formula.
I remember during the Sereno impeachment and the Sereno co-warrant to trial, yung discussion nyo among lawyers that if we oust Chief Justice Sereno on the basis of SALN, it would open a can of worms for all justices, all lawyers, or even all members of the judiciary. Is this precisely what you were fearing in 2018?
Yes, and in fact, it was reflected in some of the opinions in the Sereno decision. Actually, they recognize that this would actually open up vulnerabilities against justices of the High Court, right? Because precisely, it's a very simple issue. Did you file or did you not file? No? Decades ago, when you were a young lawyer, did you or did you not file, or did you perhaps did not think about it like it was something that you should do because 20 years later you will be a justice of the Supreme Court. No? So basically, that was the reason why, we in the board, the IBP, also intervened to question the co-warrant against Chief Justice Sereno.
So, for starters, let's talk about the value of SALN. It has been made into this, parang glorified yung SALN if parang it's some measure of one's integrity or honesty and transparency. What do you think of SALN as of its legal value?
Well, SALN actually is a valuable instrument for transparency and of course for keeping public officials within their means or to live modest lives, as required by the Constitution. So, whereas before it was just a statute during at the time of the after 1935, I think it was a 1960s measure, and then eventually became a constitutional provision in 1987 because it was in reaction to the cronyism that was said to be rampant during the Marcos era. So it was actually a reaction to that situation where a few people get rich out of being in government positions. So it was at that time really a valuable tool. But we must also see that actually the SALN measure, according to the Constitution, is required to be public only with respect to high officials, meaning the president, the vice president, the Supreme Court justices, the members of the constitutional commissions. Those are people of high station who are actually have more capability while in office to gain money and power. So that was actually addressed to that group of people. So of course, when you say you are just a professor in the College of Law, after 2 or 3 years after graduating from law school, you are not in that category yet. No? So might not yet foresee that eventually it
Yeah.
might haunt you somehow.
So for the understanding of the public, have you ever held any public position wherein you were required to file SALN? Paano po ba yung attitude ng mga not so high public servants tungkol
Yeah,
sa
well,
SALN?
I was mid-level. I used to work also, I think, for a couple of years at the Department of Transportation,
Mhm.
Civil Aviation Authority, and also as a corporate secretary in the Charity Sweepstakes Office. Well, we did not really have problems because our secretaries would,
Right.
make kulit as say, it's the deadline for SAL and they will fill it
Yeah.
up. We sign, no? Because of course we give them a list of our assets and liabilities. So it's really no problem. The problem with UP kasi is that when you're teaching there, you're basically left on your own, no? Do your own things, and sometimes there are no people to nudge you or to tell you, "Hey, sir, deadline na po ng
Yeah.
salary." So it's actually at that level somewhat clerical only.
Yeah.
Clerical is a matter of clerical efficiency.
And I remember years earlier when they were still when the Supreme Court was still releasing the SALNs, and every time we'll track it down, Justice Leonen was always the poorest.
Yeah,
And so there's always a joke na galing kasing UP kasi kaya siya yung
right,
pinakamahirap sa
right.
kanilang
Unexplained poverty.
yeah. Sir, so when it comes to assessing the value of the SALN, where do you stand? Do you have Ombudsman Martires saying it's weaponized? Do you have some lawyers saying it's glorified? Do you have some lawyers who will say, it's the law. So if you're required to file it, then you're required to file it.
Well, as my take on that is that well, we are advancing in technology. We already can digitize everything. And I think once we adjust to technology, that will be a very simple matter only of inputting those data uh, annually. It's very easy. It's very simple. No? And to me, it's still an important tool. No? And I would not discount the importance of the SALN as far as public officials are concerned. But as I said before, there is a certain line. No? There are people of high station. There are people who belong to agencies which are actually very fertile grounds for corruption. I think this is where we should focus. No?
Yeah.
Actually, I can see the difficulty also of the ombudsman because sa totoo lang, every professor, every barangay captain, these are hundreds of thousands of documents that are, wasting away there at the office of the ombudsman. They do not know what to do about it.
Yeah.
So if it is people of high station, yes, it's really very, very important.
And I think that was settled by the Supreme Court in the decision Melita del Rosario versus People. I'll just
Mm.
give a big brief background for the listeners. Melita del Rosario versus People, the ANBank settled that the prescription period of RA 6713, or the Code of Conduct for Public Officials, which governs the filing of the SALN, they said that it prescribes after 8 years. So kung lumampas na sa 8 years, you can no longer be penalized under the law. And may I just mention that this was decided in June 2018, March, April, May, June, July, June. 1 month. 1 month after the ouster of Chief Justice Sereno. Oh, what did you think of this decision when you first heard about it?
Well, I do not want to speculate as to the timing, no. But well, it was to me it is a correct decision to apply the prescriptive period, no, with respect to special to offenses punished by special laws. In this case, RA 6713 is a special law, and therefore that prescriptive period of 8 years should apply, no. But of course, this is with respect to the penal aspect, no, of the case. No? And I don't know uh, if we should relate it to the administrative issue
Right.
of either qua warrant or impeachment. Yeah.
Right. This was mentioned by Justice Carpio in his column on Inquirer. So he's saying that if the allegation is if the allegation is Justice Leon didn't file his SALN when he was a professor of UP, that's no longer in
Mhm.
question here because the Supreme Court already said 8 years has prescribed. So you're saying hindi siya, they're not related.
Well,
It cannot be applied on an administrative.
Yes,
complaint?
well, essentially, since this is a prescriptive period for a penal legislation, of course, you could say that it cannot be squarely applicable to administrative cases like an impeachment or a quo warranto, which seeks the dismissal or the removal of a public officer. No? Although, uh, I would suppose that the theory is that since a criminal case is actually what we call a graver, no, a graver situation for a public officer than a mere administrative case,
Yeah,
then if it is already prescribed, with more reason that you should say that
yeah,
why entertain it like 10 years after
yeah.
the fact, right? Yes.
So can the lawyers of Justice Leonen, assuming that this will pass the committee level, can they say that if I'm not a criminal under the law, then it didn't amount to an impeachable offense?
Yes, precisely. So I think it will be a very good point of defense, no, for Justice Leone.
So just going back to the decision, I just can't help but
Uh,
ask it. Para ang convenient naman for the Supreme Court to say a month after ousting the Chief Justice and say, after 8 years it has lapsed, when it's the very issue with Chief Justice Sereno, it's her UP days.
Well, I cannot speculate, no, as to the mindset of the justices, but well, it's possible that the lawyers of the Chief Justice failed to point it out, no, that there is such a prescriptive period for special penal
Right.
laws, no. But yeah, it is really curious that it happened like the decision was rendered like a month after the Republic versus Sereno was decided.
So, sir, as a spectator, looking at it from where I am, it seems like they ousted the Chief Justice and then protected themselves after.
Well, I'm sorry, I cannot say that I share your
Yeah.
opinion, but I don't blame you for yeah.
Okay, sir, I'm going back a few months back when the Supreme Court en banc unanimously rejected the requests of Solicitor General Jose Calida for the silence of Justice Leonen. What did you think of this? What was your view of what the institution was doing? Was they sending a message, making a stand? What did you think?
Oh yes, definitely. We should look at the current composition of the Supreme Court already. No, this is now a Supreme Court that has actually undergone several changes. No? They have had uh, three chief justices after the ouster of Chief
Yeah.
Justice. And there are younger members of the court, no, new members of the court, and I think this is in reaction actually to what Justice Leonen himself predicted, no, in his dissenting opinion in Sereno, that we might be vulnerable to an aggressive Solicitor General, no? And this is what is happening.
Yeah.
It is precisely laying the court vulnerable to the executive department, that is aggressively pointing out, potential weaknesses, on the part of the individual justices.
So is that move to reject the request of Solicitor General Calida? Do you see that as the Supreme Court standing by the institution, not protecting in the negative sense, but protecting the institution from attacks such as that?
Yes, yes. I think it is a step towards the right direction. No? The Supreme Court is a co-equal a branch of government. And actually, in the preservation of our democratic rights, it is the Supreme Court truly that holds the door, no? That actually, decides everything, to balance everything out, no? To protect the interests of individuals as against the interests of government. And in this case, while it may be seen as protecting themselves, it is actually a correct direction towards independence from the executive department.
Can't help but ask this also, public record naman, as a dissenting opinion ni Justice Kagiwa.
Yeah.
Does it make a difference that Justice Leonen is probably more liked or well liked by his colleagues in the Supreme Court? That's why there's this standing by him.
Well, I don't know. I cannot really, think like them. No, some of them are acquaintances. No, but of course there are rumors and there are anecdotes, and
Yeah.
yeah. Well, I guess from a person-to-person perspective, it also helps that you maintain really cordial relationships with your colleagues in the judiciary.
One thing that was also noted by the public and some spectators is that there's only one endorser for Leonen, and it was the cousin pa of Senator Bongbong Marcos. As opposed to Chief Justice Seren, there were 26 endorsers. Ano kaya yung the differing factor between the two of them?
Well, yeah. I think context can provide an explanation. No? In the case
Right.
of Chief Justice Sereno, it was I think there was a honeymoon. That was the honeymoon period, no, of the president with the public, and he was, that was the time when the drug war was at its peak, no, and the Chief Justice at that time actually tried to set boundaries
Yeah.
on the jurisdiction between the executive and the judiciary with respect to judges who are in the drug list, no, of the police and the drug enforcement agencies. And many congressmen at that time were really enthusiastic, no, about the cause. But currently, I mean, nearing the end of their terms of office, no, uh, I cannot see similar enthusiasm on the part of
Yeah.
congressmen. No, we have a different speaker now, and he might have a different set of ideas. The chairman of the Justice Committee of the House, Congressman Rodriguez, is very level-headed, no, well
Yeah.
grounded in constitutional principles, no. So I think this is an entirely different ballgame.
Mhm.
Not as storied as that against the Chief Justice Sereno.
Putting it also in the context of President Duterte, this was also mentioned in the dissenting opinion of Justice Leonen. Sabi ni Justice Leonen sa dissenting opinion niya, um, paano magagalit ang presidente kay Chief Justice Sereno when their decisions mas parang hindi rin naman ganun ka-dissenter daw si Justice Sereno towards the interests of the president. Parang nilista niya yung mga concurrence ni Justice Sereno. So in the context of Leonen, siya yung mas fierce dissenter. He has dissented in everything that President Duterte is interested in. So my question siguro is, why is there not an enthusiasm if we're talking about a justice na mas fierce yung dissent towards the administration?
Well, I can only, at best speculate, no, as to the mindset of the palace, no. But truly, Chief Justice, practically speaking, is a different kind of justice than an ordinary member of the court, no. Of
Right.
course, Justice Leonen, by his lonesome, cannot, uh, even if he's a constant dissenter, no, could not really, make that much of an impact. Sorry to say, no, in those cases. No? Although the dissenting opinions would be magnified and, of course, circulated, but that's it. But a Chief Justice is also the administrative head, no, of
Right.
of a separate branch of government, a very crucial position.
Right.
So that and of course, plus the fact that the president is also nearing the end of his term, no, and might have a different mindset already with respect to that.
This is also what the reporters have noticed. Now, during the time of Chief Justice Sereno, President Duterte would publicly mention Chief Justice Sereno in his speeches, as well as the others officials he would publicly, call out. He hasn't done that for Justice Leonen. So in our minds, parang, yun ba yung kulang? Walang signaling mula sa Pangulo.
Yeah, I guess. So that's probably the explanation why there's only one endorser. And the endorser comes from the north, right?
Yeah.
Yeah.
Which highlights really the very, very political nature of an impeachment.
Yes. It is a political process. In fact, in impeachment cases, now they do not follow our rules that we follow normally in courts of law, where the presentation of evidence is very strict, very stringent. No, everything is by the book. In
Yeah.
impeachment cases, they follow their own rules. They can relax everything, if they want to impeach you. Yeah.
Sir, mentioning the elephant in the Zoom room, is it the pet factor because he's the member in charge of the vice presidential electoral protest, and the endorser is the cousin of the one who filed the protest against Vice President Leni Robredo? What do you think?
Well, I can only comment as an observer, of course. Well, what preceded this was actually twin motions
Yeah,
for the inhibition, no, of Justice Leonen, one coming from the camp of the Protestant, and the other, ironically, coming from the office of the Solicitor General. No? And since it was not a successful motion,
yeah.
of course, there has to be something else, no, in order to hasten the resolution of the protest. And we are nearing. It's already almost the end of the year, and the filing of certificates of candidacy for the next round of elections would be October of 2021, which is like 10 months from now. No? So there is that urgency, I'm sure, on the part of the protester.
May I just mention also for context that Solicitor General Jose Calida was a campaigner of Senator Bongbong Marcos during the vice presidential elections in 2016. What did you think because the progression of that motion? First, they denied it, the motions for inhibition, and they issued a show cause order to the Solicitor General Calida to explain why he shouldn't be cited in contempt, and then withdrew withdrew the show cause against him and the reporter of Manila Times. What do you think of that parang atras abante?
Well, I really have no idea why they did that. No, I thought that the show cause order would be pursued, no, to its final conclusion. Well, there are certain, chismis that it was Justice Leonen himself, I think, who who convinced his colleagues or whatever. I don't know. I really don't
He
know.
sent a letter saying that parang it's better to forgive them rather
Yes,
than
yes,
issue a
yes.
show
So,
cause
so
order.
it's public record. So it's probably that. No, he was being magnanimous about it, so it was withdrawn. But I thought, or I thought that at least, the very least, there should have been just an explanation so that we would
Yeah.
know. Yes, right.
Kasi wala namang I mean, what's the ano po ba yung bigat ng isang show cause order? Is that really something so bad to issue against the Solicitor General? Is that justified?
I well, it's no, for us ordinary litigators, it happens all the time, right?
Yeah.
But of course, if it is already people of high station, duking it out in front of everybody, then there are certain repercussions, and most likely Justice Leonen saw that there might be some repercussions that would somehow muddle the issue pending in the protest. So I guess they have their own reasons that they did not divulge. No? Why eventually they had to withdraw the show cause order.
Like, hindi rin naman sila takot mag-contempt kasi si Chief Justice Sereno, after ousting her, they also cited her in contempt.
Yeah.
Naalala, naalala ko lang.
Yes, yes. There were sanctions imposed
Yeah.
against former Chief Justice. Yeah.
So going back to the impeachment complaint against Justice Leonen, which of the grounds we talked about Salen, which of the grounds you think have absolutely no leg to stand on?
Well, I can only speak from what I have read so far, no,
Yeah.
from the news. I haven't seen the actual, physical articles of impeachment, and I think from what I've read, no, there are only two basic grounds: the non-filing of the SALN and the non-resolution, no, of
Yeah.
some pending
Of
cases.
cases. Yeah.
Yes, in the Supreme Court. What do I think about it? Well, the non-resolution, if you do that, there will be hundreds of judges, justices, prosecutors, no, who have deadlines to resolve cases, who will be out of work if you do
Yeah.
that. That's, even an ordinary prosecutor in resolving a case on preliminary investigation has about, I think, 90 days to resolve it.
Yeah.
And so many of them do not do that, no, because of the workload.
The
No?
judiciary would be wiped out if that's a
Yeah,
ground
yes,
for
yes,
impeachment.
or even the prosecution service. No?
Yeah.
So it's no, it's well, I agree with Justice Carpio. It is not a mandatory requirement that you resolve it within a certain number of days. No, it is merely directory. No, meaning that if for good reasons, if you can save them, you can at least have a flexible deadline. No? On the resolution of those issues, and it's the general rule actually, all throughout the country. So I think that is a weak ground for the impeachment of Justice Leonen. The Salen issue, well, you know, if, as I said, if prescription alone, this is worrisome because uh, uh, somehow the impeachment process has been, what do we call, devalued, no? In the sense that it has become like a discovery
Circus.
process. It's a
Yeah.
discovery process by which a complainant can draw out certain admissions, no, in the
Yeah.
answer in the impeachment, and then eventually use them in the court, no, for co-warranto. No? I think. By denying the initial inquiries of the complainants, the Supreme Court actually said, "Well, stop this already."
Yeah.
you know,
Yeah.
so I think the congressman should take a step back and say, baka ginagamit lang tayo dito, no?
Mhm.
Are we being used to actually draw out those admissions or evidence from the respondent so that eventually another case can be used, or even just a ground for inhibition, a second motion for inhibition on the basis of those admissions, if the justice is required to file an answer in that impeachment proceeding.
Yeah, I remember that in the Sereno impeachment, I think we went months and months in the House of Representatives talking about the
Yeah.
centralization committee, survivorship benefits
Uh,
before they got to Salen, and
yeah.
then they
And
found it,
even
and then they follow
And
Warrington.
eventually, in the ponencia, in the majority opinion, several of those admissions and proceedings were cited in support of the co-warranto decision, right? So, it was kind of a discovery procedure. It was like a deposition that was used eventually against the Chief Justice.
All right, down to my last two question, attorney. Medyo general na to. How does this impeachment threat against Justice Leonen affect the judiciary, which has been, been through a lot, including the Supreme Court? Parang hindi na sila nakabangon from the Corona impeachment and then Sereno,
Oh, yeah.
Cuaranto ouster. How does this affect them
Well,
or the institution?
yeah, it's a bit of a cliche, no? But it is true. Actually, the weakest branch of government is the judiciary. No? They are the only branch of government appointed, no? Who owe their positions to an appointment, no? from the president. No? And do not have, of course, the implements, no? of the other branches of government. No? So that in the assessment, if you read the World Justice Project report, no,
Yeah.
yeah, the rule of law, in the rule of law index, we are very weak here in Asia, one of the weakest countries in Asia, precisely because we lack those checks, no, against government authority. And for the justices to be vulnerable to all these cases, if we read the Constitution, the it is the justices of the Supreme Court only who are required to be subjected to those subjective criteria, no, probity, integrity, competence, independence, no. The others, the president, the vice president, the congressman, the
Yeah.
senator, only need to be at a certain age,
Able to read and write.
right, etc. And those are objective criteria, no, meaning that either you have it or you don't, right?
Yeah.
Uh, in the case of the justices, they have those subjective criteria, meaning that they have to prove probity, independence, competence, integrity, and that should have been established at the level of the Judicial and Bar Council. That should
Mhm.
have been the period to that. That should have been the end of the story. You can no
Yeah.
longer go back to that integrity question. That's what we have been asserting all along. so that
Right.
you will no longer be vulnerable to all these attacks, 10 years, 20 years after the fact, with respect to your integrity. And that was contained, I think, in the dissenting opinion of Justice Perlas Bernabe.
Yeah.
And I hope eventually that would be the rule, so that all these things would be clear and the justices would really be protected in their tenure, as spelled out in the Constitution.
Yeah, that was also what I noticed during the Sereno quo warranto ouster, is that parang hindi mo pwedeng gamitin ang quo warranto against, for example, the president or the vice
Yeah.
president. Kasi ang requirement lang nila sa Constitution is at a certain age and able to read or write. So
Yes,
wala kang i-disqualify
correct,
doon.
correct. Residence lang, tapos na, no? Uh,
Tapos na. So,
yung mga justices, so while they are in office, that question will always be there because that is a requirement in the Constitution. So if you allow co-warrant or impeachment on the basis of that, when tapos na dapat ang usapan at the level of the JBC, you render them vulnerable to attacks, interminable attacks throughout their tenure. And because they are vulnerable, they can no longer render decisions in accordance with the facts and the
right.
law, and will be truly, the target of attacks of powerful interests. No?
Mhm.
Uh, and we should protect them from that.
Right. May I just mention also the still pending petitions before the Supreme Court, which are high stakes, which is a vice presidential electoral protest, the war on drugs, the
Mm.
withdrawal from the ICC, among
Yes,
others. So,
yes.
how would this? Do you think it would have a significant effect on how rule of law works in the country, how accountability is exacted in the country?
Yes, yes. If the if Justice Leonen, successfully hurdles this, it will really strengthen the judiciary. And I hope that will happen because we need the justices to be in their best lights, to be free from pressure, free from stress, in deciding these very important cases
Mhm.
moving forward. Of course, we are always hopeful that regardless of who appoints them, precisely because they have been vetted by the JBC and that all those factors have been taken in, that eventually the justices will really and truly, decide those cases based on their training,
Mhm.
and not on the basis of extraneous circumstances.
Siguro I just would like to make a point of you cannot impeach or oust a justice if you don't like their decision or whatever. Siguro kung reverse and we have a justice who we don't like his opinions, his decisions, his concurring opinions,
Mm.
the same would also apply. You cannot oust or impeach him based on that because it's already his decision.
Yes, of course, of course. Ganun talaga. If you litigate, you don't like the decision of a trial court judge.
Mhm.
You have remedies. You have certain remedies. But of course, the different thing is that when it is the Supreme Court deciding already, that's the final word of the
Mhm.
matter.
Yeah.
So truly, we should respect the decisions.
Yeah.
You know, there's nothing to reverse it after the Supreme Court. That's right.
Maybe strengthen or support the screening process so
Mhm.
only the best ones are appointed to the Supreme Court,
Yes,
which
yes,
again falls on the JBC.
right, right. It's the JBC. I think that is one constitutional body, that needs a re-evaluation or re-examination, so that it will truly function as what it was perceived or what it was as how it was envisioned by the framers of the Constitution. It was actually a noble purpose. It was to insulate it from the appointments in the judiciary, to insulate it from politics, by making judges and justices undergo the process of the commission on appointments, who are all made up of politicians. So it was a noble creation by the framers of the Constitution, and I hope we can uh, uh, you know uh, improve, the systems in place in the Judicial and Bar Council.
All right. Thank you so much, sir, for that interesting and enlightening discussion. Thank you
Yes,
for being with
anytime.
With Rappler Talk. That was Attorney Biel Dan Elijah Fajardo, the former national president of the Integrated Bar of the Philippines. This is Lian Juan. Thank you for watching Rappler Talk.